Begin.
Okay, good morning, Jim. Okay, so here we go. So the meeting comes to order. Good morning. As chairman of the Albemarle County Board of Zoning Appeals, I call the meeting for October 6th, 2020 to order. This is an electronic meeting. Please be patient as we all become familiar with this meeting alternative and virtual process. The meeting is being held pursuant to and in compliance with ordinance number 20-A, parentheses 14, an ordinance to ensure the continuity of government during the COVID-19 disaster. The BZA members who are electronically present at this meeting are, and I will name them if you could just sort of say, acknowledge your presence. So Randy Reinhardt.
Present.
Marcia Joseph. Actually, Marcia's computer may have cut off now.
Mm-hmm.
It looks like we've lost her for the moment.
Yes. I'm not sure how to deal with that.
We can just pause here for a moment because she had a problem a minute ago and she just logged out and logged back on. So I'm sure she'll be right back.
Okay. Good morning, Bo. And also present is Mr. Carrington, Mr. Edward Carrington. And we're paused for the moment. Marcia Joseph was here, but has lost her internet connection, and we're hoping she can reestablish that quickly.
Andy, we are still an official meeting with three of us. Is that correct?
That's correct. You all have a quorum right now because you have three members. So you have the ability to conduct business.
Okay, some of this, let's sort of move along, continue to move along slowly but surely here. For the benefit of the public who is listening to this, I want to continue with the announcements I was making. The opportunities for the public to access and participate in the electronic meeting are posted on the Albemarle County website on the Board of Zoning Appeals homepage and on the Albemarle County calendar. Participation will include the opportunity to comment on those matters for which comments from the public will be received. Actually, today, there are no public hearings, but you are welcome to hear the meeting, which will include a training presentation from Andy Herrick. In addition to the folks that I just mentioned as being present, I want to also introduce James Bowling, who is the Board of Zoning Appeals attorney, Bart Savoda, who is the zoning administrator, Andy Herrick, who is the deputy county attorney. I also see staff members Francis McCall and Rebecca Ragsdale are here. And Marcia Alley, who's the Board of Zoning Appeals clerk. So good morning to all, and I look forward to Marcia Joseph's reconnecting as soon as possible. Start by saying, just to repeat, there are no public hearings scheduled today. So we move on to a review of the minutes. I wonder if anyone has any comments on the minutes. I do.
Mr. Chairman, I do not have any comments.
Okay. Mr. Carrington, comments on the minutes?
No comments.
Okay. I noticed a problem with the minutes, I think, on page, where is it? On page 7, it seemed to there just seems to be a big gap in them there's this was in the section about the, the bundle sign. And we got to the point where there was a motion which was made. And then the next thing you see is the approval of the minutes. So there's a whole section left out that deals with the second, the voting, the recording, the conditions, all of that was left out. There's a glitch there.
Mr. Shepherd, where it says motion, within that paragraph, it says Ms. Joseph moved. And then the last line 42 there on page 7 says Mr. Reinhardt seconded the motion, which passed unanimously.
I'll accept that. Can we delete the last 4 minutes of the minutes for the next meeting? Moving right along. Okay, so with that,
Mr. Chairman, I move for approval of the September BZA minutes.
okay, is there a second?
Seconded.
Thank you. So the motion to approve the minutes has been made by Mr. Reinhardt, has been seconded by Mr. Carrington. Ms. Alley, will you please call the roll?
Mr. Carrington?
Present.
Would that be an aye or a
Sorry.
nay?
Aye, yes.
Okay. Mr. Reinhardt?
Aye.
Mr. Shepherd?
Aye.
Okay.
So that motion, we do have a quorum. That motion passes. So those, the minutes are approved, and I appreciate the folks that work on them. All right. I want to move to old business. Bart, do you have anything to report to us on old business? In particular, I would just say, I hope you include in that any updates on the mouse variance.
So currently, and Andy, you can jump in if I get this incorrect, but we're kind of in a holding pattern with that. Mr. Moss has submitted a plat that actually adjusts the property line. He's doing a boundary line adjustment that would that we actually signed yesterday is the update. So it's approved. Once recorded, the building would then meet the structure setbacks as required by ordinance, and the appeal would be moot at that point.
It's the appeal, and then, so when you say the appeal will be moot, does that mean the two actions in front of this that the county's brought, both about the appeal and also the variance to circuit court, will be withdrawn, or is that going to be pursued, or is that something we can't talk about now?
Mr. Chair, if I might respond to that. So at this point, there are two appeals. Procedurally, there are two appeals that are pending before the circuit court. There are appeals of both of the actions, and it's our hope that once this matter resolves, or once the boundary line adjustment becomes finalized, that'll remove the need for those appeals to be pursued further.
Okay, thank you. I'm glad to hear that, but I also was kind of curious about the outcome, but I'd rather drop it and move on. Thank you for that. Any other old business from anyone?
No, sir.
We have new business. And the new business is, this is, just tee this up quickly, that Mr. Herrick is going to provide some training today. This is the same training, I think, Andy, that you do for at VCU. So this is something that really, that I'm proud of our county as being in the forefront of really training others, so really throughout the state, with the with the work that was done on the land use handbook by Greg. And I know Andy and the rest of the legal folks here are constantly updating that. It's a living document. Has great value to, it's a very valuable thing. And I'm glad you're carrying on that tradition, Andy. It's just proud of that. And with that, I would just and also I would say that I'm really happy that all of us are going to hear the same thing at the same time as we go through this training. I think many of us, we all have different experiences that we bring, but we all know a lot, but to hear it at the same time, the same place, I think is very valuable, and it's going to help the BZA and its deliberations. And I think it's also, I'm glad that Francis McCall, Rebecca Ragsdale, and any other staff folks who would be part of this, it's going to be helpful, I think, for the staff and the board also to hear these things together. I'm really happy we're doing this. And with that, take it away, Andy.
And
If I could
Chairman,
just
we're,
interject here
Yes.
for a moment, Mr. Chairman. I wanted to make note, just for the record, that Ms. Joseph has rejoined the meeting, just so we have her marked as present.
Oh, thank you for that. Marcia, we did approve the minutes, and I think you heard the rest of it. Welcome
Marcia,
here. Hope
Marcia,
you're connected. Stay strong.
This is Francis. It looks like there's another phone number in. Is that Mr. Rob?
No, we
962.
have moved, the 1449 has been moved to a panelist.
Okay.
That is, one of the members has a phone number that they would prefer to use as their audio.
Gotcha.
And that has just been made available.
Gotcha.
So that is not Mr. Rob, unfortunately. I'm sorry.
Mr. Chairman,
Yes.
under new business, because of Ms. Joseph's exit, it occurred to me, if that happens in future meetings, how do we get to you guys if we're out there and we've been cut off and we want to let you know we're trying to get back in? Marcia, can I email you, or can we email you and say we're trying to get back on, or so it's in the present moment?
Generally, I'm not monitoring the email. I'm focused on the Zoom meeting itself. And if there was a chat, it would probably be helpful to have a phone-in number available just to call in by phone, because that I would see before I would see an email.
Okay. So if you could give us that in case this happens again. Thank goodness Marcia's back, but we didn't know whether we'd ever see her during this meeting.
Right. That should be included on your invitation. I'll double check that. If it's not, I will make that available. Yes, sir.
It's probably, I missed it. It probably is there, but I just never thought about it. The second thing is, with this meeting starting at 10, is there any consideration that we, Andy, you're going to have to pipe in, that we move? Would you all prefer 10 instead of 2 for our regular meetings, or is there a specific reason we need to stay with 2? I think Marcia brought it up. Did you last month about having this at 10 in the morning?
So, Mr. Reinhardt, I don't have a preference one way or the other. I don't know what other staff's availability is. That's the first time that I had heard of, perhaps potentially moving
Okay.
the meeting time permanently. That might be something to look into.
I'm floating it probably at the wrong time. So I'll talk to John offline. Let me get out of the way and turn things over to you, sir.
Okay.
It's something that we do at the first of the year, is we look at our schedule, right?
We'll look
Right,
at
but you have the ability to change that whenever you want to, assuming that you've got the availability of a place to meet and staff can do it.
Mr. Chairman, if you'd like, in preparation for the schedule for 2021, I could speak with facilities to see what the availability is of Lane, in hopes that we do return there someday, but just to make sure that when we do get our schedule in stone, that we would have that what the availability would be in Lane as well.
Okay. I appreciate that. I think it's, I I personally would prefer a morning meeting, but I understand there's that would be turning a lot of wheels to make that change, because so many people are just have schedules that are already set. So let's explore that. That's a good point, Randy. Thank you.
So if we're ready to proceed, I'll go ahead. I want to thank the chair and the members of the BZA for inviting me to speak this morning. As the chair alluded to, this is a presentation that I've given annually for the last several years at the Land Use Education Program that's now hosted by VCU. Matter of fact, just this morning, I got an invitation to return there this year. I had it on my calendar as being Thursday and Friday of this week, but as it turns out, they would want me to come and speak later this month. So I'm glad I had the opportunity to fine tune my presentation for you all and then maybe be delivering it to the statewide audience later in the month. Am I right that we have until noon? Is that how long we're slotted for? I just want to make sure I stay within the allotted time for everyone.
That is correct.
Okay, great. So I'll plan on going till noon, if not before. I'd invite any questions that you might have during the course of the presentation. Feel free to chime in. You don't need to raise a hand. Matter of fact, I may not be able to see who is on the line or who is raising a hand. I've actually got several different screens working here. So if my eye contact to the screen isn't good, bear with me. I'm not watching something else. I'm just watching my presentation on another screen. So speaking of that, I'm going to go ahead and share that now.
Mr. Herrick, while you're doing that, could I interject that we do have staff members as attendees who, if they have questions, would they be also welcome to raise their hands? And if that is the case, I can monitor that for you if you prefer.
I would welcome questions from anybody. So at this point, you should see my presentation screen, the powers and duties of the Board of Zoning Appeals. Do you all have that up in front of you?
Yes.
Yes.
Okay. Very well. Let me just adjust a couple other screens here to try to get as many of you on the screen as possible. Okay, so we'll go ahead and we'll start. And again, this is a presentation that I've shared with other organizations in it. And so they come to the table with a variety of different backgrounds and experiences. So I'm sure a lot of this will just be a refresher to you all, given your experience. So I certainly don't mean to be talking down to anyone. But I figure that this sort of refresher is good regardless of the amount of experience that you have. So I want to thank you for serving. Many of you have been serving for a long time, and we appreciate your devotion to the community. This is in the introduction of the prepared materials, that being an effective BZA member requires much more than longevity or common sense or the wisdom that comes with experience or a deeply felt sense of what is right or fair. It really requires knowing the applicable laws. And especially in matters of zoning appeals, the laws can be very technical, very specific, very demanding. And so it's important to really be up on the laws that the BZA deals with. And that's the hope and intent of this presentation, is really to give you all a refresher on what the applicable laws are. So today we'll cover decision makers. I'll spend a few minutes talking about both the Board of Zoning Appeals and the zoning administrator, others that are involved in the decision-making process. We'll talk about the three main areas that the Board of Zoning Appeals has some jurisdiction over, those being special use permits, variances, and appeals from determinations of the zoning administrator, specifically determinations regarding uses, nonconformities, and vested rights. And then we'll close by looking at a couple of matters that are important to members serving on any public body, and that's the Freedom of Information Act and the Conflicts of Interest Act. So these photos that are in here, many of them are from Albemarle County. This one, fortunately, is not from Albemarle County. I always have to, when I'm speaking to a statewide audience, I've got to clarify which apply to Albemarle and which don't. Fortunately, this is, I don't know where this is from. This is actually a slide that that Greg had put in here, but fortunately, it's not one of our meetings. Nor is this, but the Board of Zoning Appeals obviously is one of the major players in making land use decisions in the county. The BZA considers appeals of decisions by zoning officials. It considers applications for variances and applications for special use permits if the authority is delegated. And in Albemarle County, there is limited authority for the BZA to grant special use permits in certain areas. Board of Zoning Appeals also has statutory authority to consider applications to interpret the district map. Now, I can't recall when the Albemarle BZA has ever had occasion to interpret a district map, but statutorily, that is one of the powers of the BZA. At the bottom of some of these slides, I've included hyperlinks to the applicable section. This 15.2-2309 is a major source of law for the Board of Zoning Appeals, and we're going to refer to that section often. But again, these are the statutory powers of the Boards of Zoning Appeal.
Andy, would you give an example of interpreting a district map?
You know, that may harken to a time when the maps were more, were not as precise. I really don't see that coming up in this day and time now that we've got GIS and digital mapping. I don't know whether Mr. Svoboda has any background in terms of appeals of district maps in other jurisdictions.
Yeah, I think answer your question is when we did the pencil line drawings, it was interpretation of what that distance really was. Say if a parcel was combined or if it was subdivided, you had to figure out where that line was if the parcel line wasn't there anymore. It was mainly about accuracy of the district line than anything else, not uses or things like that.
But your reference to pencil line to me implies that in the day and age of computerized GIS, that it's likely not an issue.
Correct. Now there may be something that carries over that hasn't been, we'll call it GIS yet, that although that would be unlikely because a surveyor nowadays would, if there was a discrepancy, we would go through the records, have that line surveyed, or the applicant would propose or submit a survey, and then we would translate it and interpolate it onto the map.
Yeah, in my time with the BZA, there's been no appeals regarding or no need to interpret the district map. So that is a statutory power. State code also sets out what the membership of the BZA is. It can be 5 or 7 members appointed by the circuit court in most localities, including here in Albemarle. BZA members must be residents of the locality. They're appointed for 5 years staggered terms and may be reappointed. BZA members continue to serve until a successor is appointed. So if there's some sort of lapse in the court's appointment, there can be such a thing as a holdover BZA member while a reappointment is pending. Vacancies can be filled by appointment for an unexpired portion of a term. And BZA members by statute may not hold any other public office with 2 exceptions. One member may also be a member of the Planning Commission. And a relatively recent addition is that any member may serve as an officer of election. That's a
Happy to hear that.
Yeah, and we're glad of that too. That's actually an Albemarle initiative in recent years here. So here's one area where I actually had to update the slideshow because of Albemarle. And so we're glad that last edition is the case, that any member may also serve as an officer of election. But otherwise, BZA members are to be devoted to the BZA. And so it's interesting that this restriction exists. The zoning administrator is also a player in zoning determinations, and of course, Mr. Svoboda is our zoning administrator. By statute, the zoning administrator interprets the zoning ordinance, makes vested rights determinations in coordination with our office. A zoning administrator may grant limited modifications if authorized by the ordinance, and in Albemarle's case, the zoning administrator is not authorized to do so. The zoning administrator also orders zoning violations to be remedied and brings appropriate legal actions, enforcement. So we're going to talk first about special use permits. We've had a few special use permits come before the Albemarle Board of Zoning Appeals recently, but typically this is not as you all know, typically not the bulk of the work of the BZA. I bring this up just because in other jurisdictions, BZAs may have more authority over special use permits. Again, it varies from jurisdiction to jurisdiction. But let's talk about special use permits. It's a permit that's issued for uses that are generally consistent with by right uses in the district, but need case-by-case review because they have characteristics that potentially have greater impact on surrounding properties or the public. It brings up the lawyer's 2 favorite words, it depends. When you've got by right development, you sort of given pre-clearance to a certain use in a certain area. But when it comes to a special use permit, it's generally consistent with the comprehensive plan. But the body granting the special use permit, whether it be the local governing body like the Board of Supervisors, or whether it be a BZA, wants to make sure that it's actually consistent with the comprehensive plan. So it's kind of a check with us as opposed to just unlimited by right use. State law requires that some uses be by right in certain zoning districts. And does not allow for special use permits to be required with certain limited uses. But for the most part, localities can place reasonable conditions on special uses within districts. The authority for granting special use permits is in the code section cited there, 15.2-2286, where a governing body is authorized to grant special exceptions. That's the term in the state law. In Albemarle, we refer to them as special use permits under suitable regulations and safeguards. Now, the governing body, in our case, the Board of Supervisors, may delegate that authority to grant special use permits to the BZA. A governing body may also withdraw that authority. So it is conceivable that the governing body could delegate the authority to the BZA and then retract it. In Albemarle, I've listed the 4 areas in which the Board of Zoning Appeals does have authority over special use permits: off-site directional signs, off-site bundle signs, signs in a public right-of-way, and electric message signs. So those are the 4 areas where the BZA does have the authority over special use permits. So when the BZA is considering a special use permit, there are certain procedural requirements. A BZA must give notice of the hearing as required in 15.2-2204. That's the section that deals with published notice in a newspaper. So the notice of a special use permit hearing has to be given there. The BZA must offer an equal amount of time in a hearing to both the applicant and the staff of the local governing body, that is to say the county staff. And the BZA may impose conditions relating to the use for which a permit is granted as it may deem necessary and in the public interest, including limiting the duration of a permit, and may require a guarantee or a bond. The Board of Supervisors would also be able to impose these conditions. And you'll see these requirements again when it comes to requiring public notice and an opportunity for equal time when we look at some of the other applications that come before the BZA.
Can we go
Yeah.
back to the standards? So
Mm-hmm.
I'm just going to go back to mouse is over with, right? So I can talk about mouse.
Well, it's at this point, technically, it's still pending with the circuit court. If you could frame any questions you have in a more general fashion.
Generic way? Okay, general way. So if for instance, we felt that whatever it was, whatever variance was impacting the adjacent owner, we could require some sort of screening or fencing or whatever, so it would minimize the impact of whatever may be happening as a result of the variance to the adjacent owner.
Conditions can be added to variances, and we'll talk about variances separately. This deals with conditions to special use permits, but to answer your question, yeah, conditions can be imposed on variances as well.
And special use permits. Thank you.
Especially, sure.
Also, with this break, I have 2 questions, or really just things that I want to talk about in greater detail at some point, but I want to just put them up there right now. One, in the past, I mean, I always sort of thought special use permit and special exceptions meant the same thing, just different places had different names for them. I realized with the Yancey situation that now special exceptions are a new and different thing, and from special use permits. And at some point, I'd like to really drill into that. It's an interesting, and it's new that's all new since I worked at the county.
Well, it's a source of confusion and a source of understandable confusion in that the state enabling law refers to what we call special use permits. The state law refers to as special exceptions. So that can cause confusion when somebody's reading the state law and reads about special exceptions. Again, Albemarle calls those special use permits. But what makes it a little more complicated is that Albemarle also has special exceptions. They're just not what law would call special exceptions. So that's the source of confusion. It's more one of nomenclature than anything else.
I understand that, but I can see that things that we used to do variances for now fall under special exceptions, and I think it's a big topic, and I would like to, and I don't want to take up a lot of time right now, but I want to just put that on the future agenda.
Okay.
And along the same lines as I'm looking at this slide, I think that our work with the special permits for signs for me has been a bit confusing because I'm really not sure what the criteria is or what we're really to be looking at. It feels, and I would like that to all be perhaps clarified, and maybe either clarified or possibly revisit the idea of removing that from our purview if we're not doing something significant.
Okay.
Topic for another day, but I want it on the future agenda.
Well, it'll be a topic at least for the next couple of minutes, because the
Right.
next slide, as you can see, deals with what the decision-making criteria are for the BZA. And for those of you that follow the Board of Supervisors and the Board of Supervisors proceedings, the BZA really is kind of filling the shoes of the Board of Supervisors when it comes to those 4 types of signs. Most importantly, you're acting legislatively when you consider a special use permit. That is to say, you've got a little more discretion than you would in your administrative role. There are 2 types of decision that a governing body can make: legislative or administrative. Administrative is more check the box sort of a decision, where if something comes in and meets all the criteria, the board either board, either the Board of Supervisors or the Board of Zoning Appeals is basically obligated to approve of something if it meets all the check boxes. Legislative allows you to weigh policy considerations as well. Special use permits must be based on sound zoning principles, but neither specific standards nor findings are required. So in other words, in granting a special use permit, you don't have to say any magic words in granting it. And the materials refer to a case out of the Virginia Supreme Court from Northumberland County, where the condition was necessary to carry out the intent of this chapter. That was deemed sufficient for purposes of the special use permit. There should be standards, guidelines, or factors that may be considered that may be helpful to provide structure for the decision making. Some of them are up here on the screen: the impacts of the special use on the character of the district, the impacts of the special use on abutting and neighboring properties, consistency with the comprehensive plan, the character of the property. All these things are things that ought to be considered. But again, there's not a requirement that specific findings be made. Impacts are addressed through conditions. The conditions must bear a reasonable relationship to the legitimate land use concerns and impacts. So conditions have to have a nexus that's related to the impacts of the proposed development and must be roughly proportional to the extent of the impact. And there are a couple of landmark US Supreme Court cases that are cited there, Nolan and Dolan. And in each of those cases, there was a governing body, not in Virginia, but a governing body that exceeded its authority in imposing conditions on applications. And so what the US Supreme Court has ruled is that any conditions that are imposed must have a nexus or connection to the impact and must be roughly proportional. That is to say, even if they're in the same field, they have to be, again, roughly proportional to the impact that's being created. Conditions that are imposed are not voluntary. So this isn't a situation where there's any sort of negotiation. It's any condition that's imposed is not voluntary. So they should be imposed sparingly. They should be clear and comprehensive. So those are some of the guidelines that should guide your consideration of conditions. Denial of a special use permit application is reasonable if it's based on sound zoning principles, criteria, standards, and guidelines. If the proposal fails to satisfy all the applicable criteria, if the proposed use would have unaddressed adverse impacts, and if the standards are applied in a non-discriminatory manner. As long as those standards are applied, denial of a special use permit application is appropriate. So any questions about special use permits? Again, that's not the bulk of what the Board of Zoning Appeals does. I just bring it up first because it's first in the land use law handbook.
Andy, I have actually, I guess it is a question. In this day and time with legal actions sometimes taken, there are times when I'm reluctant to state every reason why I'm denying. My vote is a denial of anyone that has come, any issue that's come to our voting. And in the interest that it might be taken out of context if legal procedures ever take place, should I stop fearing that? Because again, taking it out of context can be damaging to the county or the appellant. I'd like to get a comment from you on that.
Well, the board speaks through its resolutions rather than comments of its individual members. So, for example, if a board wanted to articulate why it was approving or denying something, it would do so in a written resolution or a written decision. Beyond that, it's probably more appropriate for Mr. Bowling to address that. I don't want to throw him a hot potato if he's not ready, but it's probably best for Mr. Bowling to advise the BZA on that.
Don't you think, Andy, that when they're acting in a legislative capacity, special use permit area, they've got more legal protections than they do when they're doing a quasi-judicial? But then, having just said that, probably that the board has adequate legal protections. For example, if you're sued because somebody disagrees with what you've said and you've enunciated a reason for your decision which has something to do with the statutory framework involved, be it a variance or a special use permit. Does that make sense, Andy?
Yes, and as we'll get to later, the Board of Zoning Appeals is not a party or not an active party to appeals. So if a decision from the Board of Zoning Appeals gets appealed, the BZA members need not be concerned about defending their decision. The decision simply is handed to the next level up.
That's not, you're a little bit off my point. My point is something that I might say was the reason I voted against something that was before us. And then that comment is used down the road in a legal procedure. Mr. Reinhardt said da-da-da-da-da, but it could be taken out of context. So I have sort of stopped. I've been careful about what I say because it could be used, again, perhaps out of context in a legal thing.
And I think your caution is well taken. I've thought that statements and findings were helpful because they establish the record of what the BZA is thinking. But it's a double-edged sword in that there's a right reason to do things and there's a wrong reason to do things. And if the BZA makes what it thinks is the right decision but articulates a reason that's contrary to law, then it's probably better not to be on the record. But as long as the BZA is operating consistent with the law and articulates reasons that are consistent with the law, as this BZA does, then having a written record, I think, is a good thing.
Okay.
And the written record is all the court has when any appeal of the BZA decision goes before the court, because the BZA by statute is not authorized to participate in those proceedings.
That's correct.
But I think what I'm hearing is that the final decision made by the entire BZA is the most important aspect. So if it's a denial, everything that's stated within the denial, so it comes from the entire BZA and not an individual. Am I hearing you correctly?
Well, I would say, so hypothetically, if the remarks of an individual board member were brought up at trial, I would likely object and say, well, that's an individual board member speaking for him or herself and doesn't necessarily reflect the will of the board as a whole. But the board, I would say in court, the board speaks through its motions, speaks through its resolutions and orders, and that any remarks of individual board members aren't necessarily, don't necessarily speak for the board as a whole.
I agree.
That's 100% correct. That's,
Yeah.
Okay, thank you. I also want to echo what John was saying about these special use permits. I'd love for us to actually examine each and every special use permit that that the BZA has been given the authority, because the ones that we have experienced so far seem like it's one more layer for the applicant that really isn't necessary, because it's outlined within the ordinance exactly what they have to do, and the ARB in many of these circumstances has looked at this. So I echo John, and I would love to have this sort of more detailed conversation at some other time. Thank you.
Marcia, you have to realize that the Board of Supervisors in Albemarle County has made a decision to largely take on itself all decisions of any real importance, whatever that means, concerning special use permits.
I understand, but I also know that the board will revisit things from time to time. So I'm just looking at that aspect to see whether or not we have enough history with that sort of thing that it could be presented to the board that perhaps this other level isn't necessary at this point. That's all I'm thinking.
Okay.
And again, it's just one person. So, you know, we haven't made a decision.
Yeah, one last thing on statements before we move on, which is if there's a healthy discussion, it's helpful, and then Andy and Jim may want to jump in here, but it's helpful that when you do your vote or make your motion or set a condition, that you then kind of summarize in a sentence or two, not lengthy, about why that is that you're doing what that is, if you're afraid that other discussion will influence the why.
You know, that's a good point, Bart. And one thing I'd like to see, I don't know how much extra work it would be, is that you provide the BZA with findings that would be appropriate if they decide yay or nay in a particular situation. That might make their job easier, or at least focus their thinking about a decision that they have to make.
Mr. Bowling, I know that in the past we've floated the idea of preparing draft orders for the BZA, either, well, obviously when staff, there's been an appeal of a determination by the zoning administrators, we floated the idea of coming with a proposed order that would affirm the zoning administrator's determination. And not all the members of the BZA were in favor of that. I continue to think that's a good idea, to at least have a framework for the decision out there. And obviously the BZA can choose to affirm or reject the
right. And then if you do both, then I can't see any real
That's right.
problem with it, you know. And I think it's a good guide for the BZA's thinking.
Agreed. And to return to a point that Ms. Joseph was making earlier, in my experience, special use permits come before this Board of Zoning Appeals maybe once every 2 or 3 years. So it doesn't come before the Board of Zoning Appeals with great frequency. But the sentiment is that the Board of Zoning Appeals review of these special use permits is unnecessary. All that would do is revert that decision to the Board of Supervisors. In other words, eliminating BZA review of this wouldn't eliminate the review of that altogether. It would just put it back to the Board of Supervisors. But something to think about if you all feel uncomfortable in the role of granting special use permits for these areas of signs, and that's something that we would certainly talk about in the future. So if there are no other thoughts on special use permits, I'm going to turn the page into variances, which I'm sure you all are more familiar with, because that's something that comes before the Board of Zoning Appeals more often. A variance is defined in state law as a reasonable deviation from those provisions regulating the shape, size, or area of a lot or parcel of land, or the size, height, area, bulk, or location of a building or structure. Now that the definition in state law actually goes on from there, because there are a lot of provisions in the state law that state law has baked in the conditions of the granting of a variance into the definition of the variance. But we'll get to that in a moment. The nature of variances is that they allow the owner to do what is otherwise not allowed under the ordinance. They protect the landowner's property rights without destroying the zoning ordinance. So what this does is a variance is often seen as kind of a safety valve to avoid an unconstitutional taking. And I think a great example that I recall, and I think this was from before a time when any of the members here were serving, is that there was a rural areas parcel that was very shallow. I think it was only about 100 feet deep. Bart can correct me if I'm wrong here, but as I recall, the setbacks in the rural areas are, I think, 75 feet from the front and 35 feet from the back. And so you can do the math and figure out, well, you've got a 100-foot deep lot and you've got setbacks that make it literally unbuildable. I think that's a textbook example of where a variance would be appropriate, because the strict operation of the zoning ordinance would remove not only all reasonable uses, but all uses altogether of that particular lot. And that's one of the few areas where staff was more than willing to recommend the granting of a variance, because we realized that, again, the application of the zoning ordinance might constitute an unconstitutional taking.
As a staff person, I worked on one of those, the Advanced Mills lot right at the bridge where 743 hits Advanced Mills Road. The setbacks overlapped. There was about 35 square feet on the entire lot that wasn't encumbered by either the setback from the stream or the road or the sides. And they got a variance. They never built the house, but they got the variance.
So as the screen points out, variances should be sparingly granted, not never granted, but sparingly granted. And again, the examples that the chair and I just brought up, I think, are textbook examples of, if the zoning ordinance were to operate without a variance, there would be an unconstitutional taking. They should be granted only to achieve parity. You should keep in mind that variances run with the land. So in other words, you wouldn't be granting a variance just to a current owner. You'd be granting a variance that would continue on to future owners. Each variance must be considered on its own merits, although it is good to have consistency between variance applications. Again, each of them rises and falls on its own merits. And if there's an existing reasonable use of the property, it may be impossible for the applicant to establish a legal right to a variance. Because again, the main purpose of a variance is to avoid an unconstitutional taking that would deprive the landowner of all reasonable uses of a property. The authority to hear and decide applications for variances is expressly granted to the BZA in this code section I've cited on the screen. When considering a variance, the BZA is acting in its administrative capacity. So that is to say, again, it's more of the checklist format, where if it meets the boxes on the checklist, and unfortunately with variances, it's a pretty lengthy checklist. But as long as it meets those check boxes, the variance shall be granted. The BZA is empowered only to act in accord with the standards prescribed by statute. And we'll go through a number of Virginia Supreme Court cases that really show that when the law says a certain standard, that not only the law, but the Virginia Supreme Court agreed that that standard needs to be adhered to. The procedural requirements for considering a variance are much the same as they are for considering a special use permit. The BZA must fix a reasonable time for a public hearing on the variance. Notice that the public hearing must be provided as set out in the statute. The decision must be made within 90 days. That's also a statutory requirement. And the concurring vote of a majority of the membership, regardless of absences or vacancies, is required to grant a variance. So in Albemarle County, a variance always requires 3 votes. Even if there's vacancies, even if there's absences, if there are only 3 members present on a given day, 3 votes is still required. And that's by statute.
When is the 90 days? When does that begin?
That's a statutory requirement. It begins within 90 days of the receipt of the application.
Okay.
Here are some relatively recent statutory requirements. It's always interesting to see some of these procedural requirements that are adopted, because it's a pretty safe bet when amendments are made to state law. They're usually to address a situation that the General Assembly didn't like. And this first bullet point, no ex parte communications between the locality's non-legal staff and BZA members, or between the applicant and its representatives and BZA members regarding the facts or the law of a pending application. So as Mr. Bolin could tell you, what ex parte communication is communication between a litigant and the judge deciding a case. And like one of the first rules of judicial ethics, and pretty high up on the rules of attorney ethics as well, is that attorneys are not supposed to be discussing a case with a judge, a pending case with a judge outside of the hearing of the other party. That's unfair access. And either the attorney or the judge, if they find themselves starting to drift into the area of talking about a case that's pending before that judge, need to not discuss that. And apparently there must have been a situation in another locality where somebody felt as though the locality staff, the zoning administrator, had unfair access to the Board of Zoning Appeals. And this part of state law was added. This isn't to say that BZA members can't discuss pending cases with staff, but they need to loop in the other side when doing so. Another procedural requirement here is that the BZA must offer an equal amount of time in a hearing to the locality staff and the applicant. That's why we, a few years ago when this first came into play, we went back and amended the rules of procedure for the Board of Zoning Appeals to guarantee applicants have the same amount of time as the locality. Typically that's not an issue, but again, it's a guarantee of state law. And any materials, including the staff report furnished to the BZA, must be made available to the applicant at no cost. Again, to me, this seems like addressing situations that aren't the case in Albemarle, because I don't feel like our staff is trying to take an inside track with BZA members or hide the ball from applicants or anything like that. But we're required to follow these new requirements of state law as well. When it comes to the variance application being considered, the applicant has the burden to prove by a preponderance of the evidence. That is to say, it needs to be more likely than not, a 51% burden of proof, essentially, that its application meets the standards of a variance as defined in 15.2-2201 and the criteria for a variance in 15.2-2309. The variance shall be granted if the applicant shows that the standard and the criteria are met. So again, it's an administrative burden. This is the state law saying basically, if it checks all the check boxes, it must be granted. And again, the BZA is not required to make findings, although I think that can be helpful. So there are two sources of variance law, and it's important to keep them in mind because they're in different parts of the code. Sometimes when you're reading through the Virginia code, all of the requirements are in sort of the same neighborhood of the code, and it makes it very easy to follow. In this case, they're in two very different parts of the code. They're in the definition of a variance in 15.2-2201. The 15.2-2201 is the definition section. And the full definition of variance doesn't just say it's a variance from the setbacks or the building height and so forth. It goes on to say, provided that it meets this condition and this condition and this condition. So it's baked into the definition are substantive requirements for the variance itself. And then there are criteria for variances that are spelled out in another area, 15.2-2309, which organizationally is a listing of the powers and duties of the BZA. And within 15.2-2309, to make things, to make the checklist even longer, there are 3 alternate grounds that you can go by, but then there's, in addition, 5 mandatory standards. So when you add it all up, there's a total of 11 different criteria. There are 3 standards that must be met within the definition. There are 3 alternate grounds in the criteria for a variance, and then there are 5 mandatory standards. Don't worry, we'll walk through all of them. So within the definition, there are 3 requirements within the definition of a variance, and it has to meet, so the extended definition of a variance, again, isn't just a reasonable deviation from the setback. The definition of variance also says that a variance cannot be granted unless the strict application of the ordinance would unreasonably restrict the utilization of the property, and such need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance. So this is an and set of statements that all 3 of these criteria must be met, and this is part of the definition of variance. Then turning to the powers of the BZA section, here are 3 alternate grounds. This is a part of the variance standards that's an or. So a variance can't be granted unless the strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or the granting of the variance would alleviate a hardship, oops, move machine there, due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or it would alleviate a hardship by granting a reasonable modification to a property or improvements thereon requested by or on behalf of a person with a disability. Now here's an interesting drafting note. Regardless of which of these alternatives is chosen, an applicant must still meet the definition of variance in 15.2-2201, including that the strict application of the ordinance would unreasonably restrict the utilization of the property. So for instance, if an applicant comes forward and says, I'm applying under condition number 2, I'm saying that the granting of this variance would alleviate a hardship, and I ought to be able to proceed on that basis, that it's alleviating a hardship. Okay, well, that's fine. You've still got to meet the conditions of 2201, which includes that the strict application of the ordinance would unreasonably restrict the utilization of the property. Notice that this first element of the definition is the first alternative in the criteria section. So even if you say, I want to proceed under number 2, or I want to proceed under number 3, you still have to go back and prove this number 1 because it is part of the mandatory definition of variance. So an interesting drafting note that basically makes these two conditions, I guess, less applicable. So what is a physical condition relating to the property? I think this is an interesting slide. I don't know what the width of this parcel is, but they certainly had an interesting design here. It's exceptional narrowness, shallowness, shape, or size, or exceptional topographic conditions or extraordinary situation or condition of the property. The condition must be a physical characteristic of the property or its improvements as of the effective date of the ordinance. So it can't be a legal restriction. It has to be something that, whether it be the shape or the topography, that makes it a physical condition for which a variance is warranted. So that was a little digression. Now we're getting on to the 5 mandatory standards. Now we're back to the areas where that they must, again, meet all of these above. And we'll talk about each of these standards in a little more depth. That the variance must have been because of a good faith. It must be requested in good faith and not as a result of a self-inflicted condition on the part of the property owner. It can't have a substantial detriment to the neighboring properties. It must be non-recurring. There is not, use variances are not allowed, only variances from setbacks and other conditions, not use variances. And special exceptions must be unavailable as a remedy. And again, all 5 of these standards must be met.
Excuse me, Andy, just one moment. I see a chat from Marcia saying that Mr. Rob has joined the meeting, and I want to welcome him here. Just looked at for the minutes that whatever time it is, that's the time that he entered. And with that,
Okay.
glad he's here.
We will welcome Mr. Rob. We'll pick back up. So the first of these 5 mandatory criteria is that it must be requested in good faith and it must not be self-inflicted. And here's the exact language of the state law. The property interest for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant for the variance. So let's have a poster child for a self-inflicted variance application. And it comes from our neighbor, Fluvanna County, and specifically in the Lake Monticello development. That the homeowners association told the builder that it could assume that the property lines were indicated by certain utility markers. The utility markers, as it turns out, were not on the property lines. In this case, the house was constructed 8 inches from a property line where a 10-foot setback was required. That is to say, the house encroached by 9 feet 4 inches into the setback. So the BZA granted this variance and the trial court affirmed it. But when it went to the Virginia Supreme Court, the Virginia Supreme Court overturned it, that there was no undue hardship because the house could have been constructed without violating the setback requirements if the measurements had been made from the property lines. The location of utilities is not a situation or condition of the property. It must be, again, a natural physical characteristic, and therefore the hardship was self-inflicted and the owners were not entitled to a variance. It does seem like a pretty harsh result. Because after this house was built, it had to be moved or they had to make some sort of adjustment to deal with it. But if they had, it goes to show that it's a good example of what a self-inflicted hardship is, that it was important before construction of the house to have a surveyor show where the property lines were and not just build according to the utility markers. Yes, it's another good example of measure twice, cut once. The next of the mandatory requirements is that there be no substantial detriment, and specifically the language of the state code is that the granting of the variance will not be of substantial detriment to adjacent property and nearby properties in proximity of that geographical area. It must be non-recurring, that the condition or situation of a property concerned is not of so general or recurring a nature as to make unreasonably practicable the formulation of a general regulation to be adopted as an amendment to the ordinance. And what this is really saying is that it's the BZA's position to grant variances, but it's the Board of Supervisors' place to make the zoning laws. But if the BZA in its experience is finding that it's getting the same variance applications over and over again of the same general nature, there comes a point at which the BZA can recommend to the governing body that it adjust the zoning ordinance accordingly. Recurring variance applications of the same type are a symptom, basically, that there may be something with the zoning ordinance that can be improved. There's no such thing as a use variance either. Again, state law says the granting of the variance does not result in a use that is not otherwise permitted on such property or a change in the zoning classification of the property. Again, it's to make physical adjustments to the property rather than allowing uses or not allowing uses. Again, that's for the zoning ordinance that's adopted by the Board of Supervisors, by the governing body.
Could you just go back and just talk about just, I was just so, I was really just perplexed by some ideas that came out in our recent variance hearing about the idea that that by the distance from a property line with a single use, that the distance from the property line, whether it was within a setback or not, would constitute a change in use, which, as I said in the past meetings, I just did not understand that. And I still don't. And I would like to.
Well, I want
the difference between, just maybe to simplify it, or, whether, if a gas station can be within 5 feet of a line, but no closer than 5 feet of a line, versus on that same property, a gas station is not permitted in that zoning district at all. So that there should be a distinction between locations, that moving the location of a use changes the use. I think it changes the location. I didn't understand that, and I would like to understand that better moving forward.
Okay. What I think this is saying is basically that the Board of Zoning Appeals can't approve a use if it's not otherwise permitted under the county zoning ordinance. So for example, the BZA, I mean, to use your gas station example, if a gas station is not a permitted use of a residential area, somebody can't come before the Board of Zoning Appeals and for a request for a variance to allow a gas station in a residential area. And the BZA would be acting improperly if it said, we grant you a variance to operate a gas station in a residential area. Now, what it can say is it can move the setbacks if it finds that the applicant meets all other requirements for a variance, but it can't dictate what uses go on a property, because again, that's supervisors to determine through the zoning ordinance. So the last requirement of a variance is that it not be available as a remedy, that the relief or remedy sought by the variance application is not available through a special exception process that is authorized, and then it goes on to cite the various sections. And in Albemarle County, as a rule, this does not apply because, in fact, the zoning administrator is not authorized to grant these sorts of special exceptions. So this last element is automatically met in Albemarle County. The BZA may impose conditions regarding the location, character, and other features of the proposed structure or use as it may deem necessary and in the public interest, and it may require a guarantee or a bond to ensure that the conditions imposed will be complied with. So this gets back to Ms. Joseph's question earlier. She raised it in the context of a special use permit, but it's also true in the context of variances. There are two special variant situations where the county's strict standards regarding variances are are preempted by federal law, and that's the Americans with Disabilities Act and the Fair Housing Act. That localities are required to make reasonable accommodations from their policies and rules, including its zoning regulations, so as not to discriminate against disabled persons. Now, any such variance may expire when the person benefited by it is no longer in need of the modification to such property improvements as provided by the variance. So the classic example of this, for instance, would be if there was a wheelchair ramp that encroached into a setback, that regardless of whether it met the other criteria, federal law would say that the locality, including the Board of Zoning Appeals, is obligated to grant a reasonable accommodation, such as, again, allowing a wheelchair ramp to be extended into a setback, even if it wouldn't otherwise meet the criteria for granting a variance. The National Flood Insurance Program also requires the localities participating in that program. It requires those localities to adopt floodplain management regulations, which include standards for variances. We really haven't seen many of those. In fact, I can't recall any of these applications, so I don't want to dwell too long on it, except just to hang a flag here that these are a couple areas where federal law preempts even the state law regarding variances. And again, staff will alert you if either of these conditions or situations apply if and when they come forward.
Andy, it appears as if, because the ordinance is written the way it is now, that for the most part in any zoning district aside from, I think, RA and maybe VR, the Board of Supervisors can grant a special exception. So the variance aspect now is just, I'm assuming that the Board of Zoning Appeals will only be looking at variances that are requested in rural areas or village residential, because otherwise the applicant would go to the Board of Supervisors to receive a special exception. Is that correct?
Not exactly. I think you're correct in noting that the Board of Supervisors does have the authority to grant, I forget what the term was that the state Supreme Court used. There was a Fairfax County case that went to the Virginia Supreme Court, and we discussed this briefly at the last meeting, where the Virginia Supreme Court said that the setup that they had in Fairfax County, the Board of Supervisors could grant a special exception to a setback, that was allowable. I know that there's been some thinking, or the argument that's been made, that the BZA has exclusive jurisdictions over variances. And that's true, but the BZA doesn't have exclusive jurisdiction over granting, for lack of a better term, deviations from setbacks. That those can go before the BZA, or they can go through the Board of Supervisors, but they're not mutually exclusive. So it's not an either or, that if you've got one situation, you'll go to the Board of Supervisors. And if you've got another situation, you'll go to the Board of Zoning Appeals. An applicant can choose to go either way. And again, the Virginia Supreme Court has said that that's okay.
Good. But Andy, isn't Marcia correct that if I've got a setback problem in the growth area, why should I come to the BZA? I just want to file for a special exception with the Board of Supervisors.
That's the applicant's choice.
Yeah, certainly if you've got a house that's you build a house within the setback or something like that.
I would like to go, if we could pursue that later, but my reading, I did my own looking into that and found that the ordinance had been changed to allow for special exceptions. I don't have this all on the top of my head right now, but that variances are set forth as special exceptions are available in various zoning districts. This is all in section 4, general regs, and there's also some reference to special exceptions being available to for supplemental regulations. And it seems like if a criteria in the variance says that you can't grant a variance if a if a special exception is otherwise available, I don't see where the choice is. I'm not looking, I don't have it in front of me, but I just wonder, I'd like to pursue that further.
Okay. Okay. We can certainly look at whether, Mr. Chair, if you're referring to this requirement, we can certainly look into that further, whether in fact the ability to grant a deviation from a setback and brings it within this realm. We can look into that and get back to you on that later.
Thanks.
So I'm going to go through some case law that went before the Virginia Supreme Court to show how strictly the Virginia Supreme Court views the granting of a variance. Here's a case from Fairfax County. And it seems like a lot of the best precedents in variance law come out of Fairfax County. Wonder why. Anyway, the facts of this case are that there was a 20,000 square foot parcel with a house, that the parcel rose 42 feet from front to back, that the owner desired to demolish an existing house and construct a new, larger house, and that a 2-foot variance was needed for a side yard setback. So the BZA thought that the request was modest, found that the lot suffered from severe topographic conditions, again, a 42 rise in elevation, which the owner worked hard to accommodate, and that these conditions were an undue hardship, and the trial court affirmed. So again, we had a situation where the BZA grants the variance, the local circuit court affirms it. Here you can see an illustration from the property. You can see where the proposed structure does encroach 2 feet into what would be the building envelope for that parcel. There was a similar case around the same time that came out of Virginia Beach. It was an acre and a quarter parcel with a house and a detached garage. The owners desired to add a storage shed and sought a variance from the square footage limitation on accessory structures. The existing zoning would have allowed 4 dwellings. The owners claimed that the storage shed was invisible from the street with no impact on neighboring properties. In this case, the BZA denied the variance, but the trial court reversed it and granted the variance. At trial, just as a side note, the owners claimed that the hardship existed because their daughter was returning to care for an ailing parent, and the storage shed was needed to store her belongings. So in each of these cases, yes, Mr. Chair.
It would help me as you're referring to these cases, if you could cite the code that they were operating under, since are these like before 2015 or after?
So all the case, yeah, good point. So Mr. Chair is getting ahead of me a little bit here in noting that the variance law did change in 2015. For better or for worse, there have not been, and I double checked this week, for any precedent or any Virginia Supreme Court cases that have dealt with variances since the law was amended in 2015. And surprisingly, there are still no good cases out there. In fact, no cases really at all that deal with the post-2015 variances, or the post-2015 standard. All we have to go on are these pre-2015 decisions. But we'll talk a little bit more about whether these standards would still apply even post-2015. But all the cases that I'm discussing today are pre-2015 just because there are no cases since 2015.
Thank you.
So the Supreme Court, again, applying the pre-2015 law, noted that the authority of the BZA to grant variances is prescribed by statute. And that's still the case. I think the Supreme Court would find the same way today. That the BZA has authority to grant variances only if it makes all the findings required, including the finding of an undue hardship. And of course, now that standard, the specific standard has changed, but not the requirement that all those findings be made. And again, as noted here on the slide, since 2015, the prior undue hardship finding has been replaced by a standard of unreasonable restriction on the use of the property. So that's the finding that would still have to be made in order for a variance to be granted. So here's why the Supreme Court found these variances to be unjustified in each of the respective cases. In the Cochran case from Fairfax County, the proposed house could have been reduced by 152 square feet. A third story could have been added to the building. The proposed house could have simply been moved 2 feet so that it would have been out of the setback, or the project could have been abandoned. The owner still had reasonable use of the property. In Pennington, the storage shed case out of Virginia Beach, The storage shed could have been built as an addition to the existing house, and then it wouldn't have had to have worried about the setbacks. Or again, the project could have been abandoned. So the court's guidance on how to approach a variance application, here's a quote from the case. The threshold question for the BZA in considering an application for a variance is whether the effect of the zoning ordinance upon the property under consideration as it stands interferes with all reasonable beneficial uses of the property taken as a whole. If the answer is in the negative, the BZA has no authority to go further. So, I mean, the Supreme Court, I like this little meme here, the Virginia Supreme Court has said when the standards are set out for a variance, they need to be strictly upheld. Now, the chair has raised the question of would the 2015 criteria, how would they affected the cases, if at all? There are cases in your materials that, again, show a litany of other cases that the Virginia Supreme Court has strictly applied the standards for a variance. And so it raises the question of what really changed in 2015. So the burden of proof and the criteria have changed, but the criteria still establish a very high bar. And that localities, if they want flexibility in their zoning regulations, they should instill that flexibility legislatively through the zoning ordinance by amending the zoning ordinance. That was one of the things that we thought was kind of surprising about the 2015 amendments, is that we heard that they were made at the behest of some localities, but the local governing body already has the authority to amend its zoning ordinance. So if the locality wants more flexible zoning, the way to do so is by amending the zoning ordinance, rather than having the administrative body, basically the body that grants escape hatch variances, essentially, to be acting. In other words, there shouldn't be amendments of the zoning ordinance through the serial granting of variances. That the zoning ordinance should be amended legislatively by the local governing body is the philosophy behind the granting of variances, or the high standard for variances.
But Andy, you know, I think your presentation is excellent, and I appreciate it. But the counter argument is raised by landowners' attorneys that there's, you know, you say there hadn't really been a change. The landowners' attorneys say there's been a sea change, and of course the Supreme Court is totally silent on the issue. And as with all these things, I think we're somewhere in the middle. But the counter argument is that 15.22309(2) at the beginning says that it says notwithstanding any other provision of law, general or specific. So you can argue that kicks out the definition of variance that you've defined, and therefore you give effect to the General Assembly's pronouncement that this wiggle room language, which I don't really know what it means, the granting of the variance, let's see, where is it? I've lost my train of thought now.
Unreasonable restricts.
Yes, yes.
This or the, Mr. Bowling, I put up on the screen the statute.
The alleviate a hardship by granting a reasonable modification to a property or improvements thereby am requested. So they argue that you put a reasonableness standard in the thing. And if you go back and hammer hard on your definition, you say, no, that can't be because it's in conflict with the definition for the reasons, Andy, that you pointed out. And so then you're just kind of left scratching your head. But there is a gap in this statute that needs to be interpreted.
Well, and I agree, Mr. Bowling, that again, I guess locality staff is just as eagerly awaiting the interpretation. We would like to see a post 2015 case as much as anyone to help grant clarity to the standard. Again, the standard that still applies, and again, regardless of which of these options an applicant chooses to go under, it still has to meet all three of these, including that the strict application would unreasonably restrict the utilization of the property. And then it's got to meet all five of these conditions as well.
Right, but my argument is, this is a landowner's argument. This is just, I'm playing the devil's advocate, is that this is that 15.22309(2) starts out by saying notwithstanding any other provision of law, general or special, and then it goes on. And so and you can go to statutory interpretation analysis and torture a layman and say that the General Assembly's words have to have meaning and so forth.
Right.
So they created this construct, which is very, very complicated, except
Well-
for a skilled land use lawyer.
Well, and
even
that's what
then.
I realize, as I said, this is a lengthy checklist.
Yeah,
And the way I like to think about it is you've got these, oh, I'm sorry, I'm going in the wrong direction here. You've got these three at the beginning, all three of which need to be met.
well, that's your point, but what do the words notwithstanding any other provision by law mean? You know?
Right, but it does include, after the notwithstanding, it includes the language that says it has to meet the standards for a variance as defined in 2201
But then it says or.
and the criteria for a variance in 2309.2.
Yeah, I don't know, you know, I mean, I'm just, it's something that the Supreme Court needs to address, and I'm really amazed they haven't addressed it yet.
It is surprising that no cases have come up since 2015.
And then the other thing that's really surprising is that, as you pointed out, and as Marcia pointed out, you've got the variance really in play only in the RA zone, where the whole reason for having strict application of variances are not as, you know, arguably not as great, because you've got more room, lots are bigger and so forth. And every place else you've got these escape valves that are present through the special use permit, I believe.
But again, I like to think of the variance as being an escape hatch from an unconstitutional taking. And that's really what a variance is designed for.
I think you're right historically, but I'm not sure what happened in 2015.
Right.
Yeah, and
Excuse
I don't know the answer.
Excuse me, Mr. Herrick, we have a question from Kevin McCullum.
Hi, can you all hear me?
Yes.
Hi, so I had a question regarding a follow-up to one of the examples Andy presented. I was just curious, in the example where the house was built to 8 inches, I think was the total, because the county marked, you know, the utility line, and they proceeded to build thinking that was the property line. I think I understand that, you know, the BZA in that case wasn't able to grant a variance. I was just curious what the, you know, the course of action would be, you know, from the property owner to, you know, because in my opinion, you know, that mistake was created by the county. Like, I understand they could have gotten a survey, but the property owner, you know, was going on the word of the county that that was the line. So I was just curious on, you know, what that property owner would then do next.
So thanks for the opportunity to clarify, because it wasn't the county that put the utility pedestals in. It was a private utility that put those utility pedestals in. So it wasn't the county. In that case, the county hadn't made any error. And I think, again, since this was in a private development, maybe the Lake Monticello Owners Association had given that what turned out to be bad advice. So again, the locality there was faultless. And the remedies, as a practical matter, may not be as extreme as actually having to tear down or move the house. It could be approaching the neighboring property owner and working out a boundary line adjustment to where the one property owner simply buys an additional 10 feet of land or however many feet of land are needed in order to make it such that the building as built obeys the setback. That's a good question, and thanks for allowing me to clarify, because again, it wasn't the Fluvanna County government, as I understand the case, didn't have anything to do with that mistake. So that concludes the discussion of variances as I try to figure out which direction this slideshow is going. Where I went back a long way. So the next area that the BZA is involved in is appealing or hearing appeals from decisions of zoning officials. Decisions of zoning appeals that may come before, or decisions of zoning administrators rather, that may come before the BZA include the meaning of a particular regulation in the zoning ordinance, how a use should be classified and whether it's permitted in a specific zoning district, whether a proposed structure complies with setback, height, bulk, and other requirements, whether a use or structure is non-conforming, whether an owner has vested rights, or whether a lot meets minimum lot size requirements. The zoning administrator's determination are subject to the thing decided rule, and that is that state law sets out the right of people that are aggrieved by the decision of a zoning administrator to appeal it to the BZA. If this mandatory appeal is not timely filed within 30 days, the zoning administrator decision becomes a thing decided and thus not subject to court challenge. So basically, if somebody is aggrieved by a zoning administrator's decision, the clock is running for them to appeal it to the BZA. And if they fail to appeal it to the BZA, then it becomes a final decision. So we're going to look at appeals of certain types of decisions. So what types of decisions can be appealed to the BZA? Well, any decision of the zoning administrator and any order, requirement, decision, or determination made by any other administrative officer that was made in the administration or enforcement of the state zoning laws or the locality's zoning ordinance. Those are the types of decisions that can be appealed. So it need not be something that's on formal county stationery. There have been determinations that have been made where either the zoning administrator or some other county official has given an oral interpretation from the dais of a meeting. And that was deemed to be an order, requirement, decision, or determination made that was appealable. I know that that in our language, sometimes the zoning administrator will put in disclaimer language to say this is not an official determination that can be appealed from. And in other determinations, specifically notices of violation, we will include the specific language that says this is an official determination that must be timely appealed or it becomes final. But again, it need not be a formal, what we might consider a formal determination in order to be appealable to the Board of Zoning Appeals, and it need not be made by the zoning administrator personally. So here are types of decisions: determinations of whether proposed activity is a permitted use, decisions by the zoning administrator to approve or deny a request for a modification, notices of violation, that's a frequent source of appeals, and orders to bring a parcel into compliance with the zoning ordinance. So there's also a minimum standard for standing to appeal to the Board of Zoning Appeals. In order to have the right to appeal, the appellant must be aggrieved, and that is a legal term. A person aggrieved must have an immediate pecuniary, that is monetary, and substantial interest in the litigation and not a remote or indirect interest. Let me go back up and note also that an office, department, board, or bureau of a locality automatically has standing. But in terms of a person aggrieved, what this does is this prevents public interest groups from having standing in these sorts of appeals. Typically, anybody that wishes to appeal must be the owner, him or herself, or must be a neighboring owner, or must be a nearby owner. That if an owner that lives remotely from the site of a decision attempts to appeal, they likely don't have standing because they wouldn't have, again, what the standard calls for, immediate pecuniary and substantial interest in the litigation. So for better or for worse, again, this bars many people that are unhappy with decisions from being able to appeal them. Yes.
I think I know the. So for an adjoining owner to appeal, they would have to know that the determination had been made on their neighbor's property and appeal that. And if they, what happens? Does an adjoining owner have any standing if they did not appeal within 30 days, but had no way to know that the determination had been made?
They're deemed to have constructive notice. So the answer to your question is no, that even if the neighboring owner did not receive actual notice, that they are as bound by the 30-day appeal period as any other aggrieved person. I think that's the reason for the public hearing requirements. The thought is that those will reach neighboring property owners. So as we've noted, the appeal must be filed within 30 days after the decision by the person aggrieved or by the officer or entity of the locality. The appellant must specify the grounds for an appeal. And as we've noted, if an appeal is not timely filed, is not brought by a person aggrieved, or if the appeal fails to specify for the grounds for the appeal, the BZA may dismiss the appeal. So if it doesn't meet all three of the requirements, the BZA may dismiss it. This last point, even though it's a sub-point, is an important one. I frequently told staff that have been processing appeals that we know are untimely, that just automatic dismissal, that staff cannot dismiss applications. So for example, we've received applications or appeals before that have been filed on the 31st day or the 32nd day, or outside the timeline. And obviously that ought to be an obvious automatic rejection. But just so you know, staff does not screen out those applications. We will bring those untimely applications to the BZA with a recommendation that they be denied as untimely. Staff doesn't simply, again, take the application and throw it in the trash or fail to accept it. We will bring it to the BZA. But again, it's the BZA is then obligated to dismiss it as being untimely filed. So the effect of filing an appeal to the BZA is that an appeal stays all proceedings in furtherance of the action appealed from. So this most frequently comes up in the context of notices of violation. If a property owner is sent a notice of violation and the county is pursuing, for example, civil penalties in the district court, the property owner can file an appeal with the BZA, and that will stay the county's attempt to collect civil penalties from the property owner in the general district court. Now, the BZA may lift the stay if the zoning administrator certifies that the stay would cause imminent peril to life or property. So again, following that example further, if the county were pursuing court action and the appellant appealed it, the zoning administrator could then come to the BZA and say, no, this is really important that this violation be stopped right now because it's causing an imminent peril to life or property. But then the appellant can then go to the circuit court and say, no, we want you to reimpose that stay. So you can kind of have a battle of whether or not the stay is lifted or imposed. But the default rule is that there is a stay on proceedings in court if an appellant appeals a notice of violation or other determination to the BZA. So we see here that many of the same procedural requirements for the consideration of an appeal from the zoning administrator's determination. BZA must fix a reasonable time for a public hearing, must give public notice of that hearing. The decision must be made within 90 days of the application for the appeal, and the concurring vote of a majority of the membership, again, regardless of vacancies or absences, is required to overturn the decision appealed from. So it takes, again, 3 votes, and in the event of a tie vote, for instance, if a 2-2 vote, I guess would be the only scenario in which that could take place in Albemarle. A 2-2 vote means that it is not, that the finding or the determination of the zoning administrator is not overturned. It's not necessarily affirmed, but it's also not overturned because it requires 3 votes in Albemarle to overturn a determination of the zoning administrator. We see here the same requirements that exist for variance applications, that there's no ex parte communications, that both sides must be brought into any discussion of it. The BZA must offer an equal amount of time to both sides, and that all materials must be shared with both sides. Again, some of the same requirements you see in other contexts. And the issue for the BZA is whether the zoning official's determination was correct. The 3 alternatives are to reverse, affirm, wholly or partly, or modify the zoning administrator's determination. So that's what, and that's what staff was attempting to do by preparing proposed orders, was basically to say, when a zoning administrator's determination is appealed from, you basically have 3 alternatives: uphold, reverse, or modify either partly or wholly. But in considering the appeal, the BZA may not determine whether a proposed use is appropriate, determine what's in the public interest, amend or repeal a zoning regulation, determine that a zoning regulation is invalid, or consider the constitution of a zoning regulation. Those are all kind of outside the scope of what the BZA is being asked to do. BZA is simply being asked to do, was the zoning determination correct or not? Yes or no? And again, you've got the ability to modify the zoning administrator's determination, but not to essentially rewrite the zoning ordinance. There should be a clear statement of the basis for the appeal, and we think that appellants should be held to the standard that the appellant's written appeal must clearly state the basis for the appeal, that the basis of the appeal should frame and limit the issues on appeal. It's the same way when the county or when any party appeals a matter to the Virginia Supreme Court. One of the requirements is that you state the error that was made in the court below, and state the issues that you want to appeal. And I think that the appellants before the BZA are under the same, have the same requirement. That if the statement is unclear and needs further information, the BZA or its staff should ask the appellant to elaborate on the basis for that appeal. And then BZA decisions in turn can be appealed to circuit court. That's the next level of appeal. That appeal must be filed within 30 days after the BZA decision. Again, it needs to be filed by a person aggrieved, any aggrieved taxpayer or an officer or entity of the locality. That the locality, the property owner, and the applicant or appellant before the BZA are necessary parties. The governing body, that is to say, in our case, the Board of Supervisors, must be included in the filed petition within 30 days. And the BZA is not a party to the case. Its only role is to prepare the administrative record. So that was a change in state law of about 8 years ago, where, again, it used to be that the BZA itself was brought in as a party on the appeals to circuit court. Nowadays, the BZA's sole role is to prepare the record, send it on to circuit court, and then the BZA is not involved in the appeals any further.
Can we go back to the 90 days and the, if the BZA is requesting additional information from either staff or the applicant or appellant or whatever during the hearing, you can then ask for a deferral of this item. The BZA can, to a specific date. Does that fit into that 90 days at all, or does the hearing itself fulfill that requirement for the 90 days?
So the 90 days can be extended at the request of the applicant or the appellant, but the appellant or applicant has a right to have a decision within 90 days if they so choose. So that's why if a deferral is being discussed, we always want on the record whether or not it's being requested by the applicant. Because absent a request by the applicant, the BZA has to act within 90 days. Now, as the materials point out, courts have found that if the 90 days isn't observed, it does not deprive the BZA of jurisdiction. There was one case in particular where I think the matter was pending before the BZA for 500 or 600 days or something like that. And the court didn't rule at that point that the BZA lost its jurisdiction to make a decision. But it's best to stay obviously within the requirements of the statute, which is that it be decided within 90 days.
Okay, and what you're telling me, just so I've got it clear, is that it's not up to the BZA to decide, they defer it, it's up to the applicant or appellant to defer it, to request a deferral.
It is up to the BZA to decide whether to grant a deferral. The BZA should not grant a deferral past 90 days unless it's requested by the applicant.
Unless, okay. Thank you.
But there's an easy way to get around that, Marcia. You simply say, we're in a real quandary here. We're running up on our 90 days and we really need some additional information. Will you request a deferral? And then the applicant can say yes or no. And if he requests a deferral, then you're in the clear for the 90 days. And if he doesn't, then you act appropriately.
Okay. Thank you.
I'm going to talk a little bit about how the zoning administrator goes about interpreting statutes and ordinances. And I see Mr. Svoboda laughing at this. This, I might add, is also not an illustration of the Albemarle County zoning administrator here, although I guess we've all had days like this at some point. So who's responsible for interpreting the zoning ordinance? At the staff level, the task of interpreting the zoning ordinance and proffers is assigned to the zoning administrator. But on appeal from the zoning administrator's decision, the BZA is the one that's authorized to interpret the zoning ordinance. So on appeal, the BZA essentially becomes the zoning administrator. So what's the correct approach to interpreting an ordinance? What should you look at when filling the role of making these determinations? Should you focus solely on the text of the ordinance, ignoring evidence of legislative intent? And the answer to this question is hard for some people to accept. Yes, that you should ignore what you believe to be the intent of the ordinance. As I'm always telling staff, words on the page, that you really, if the words on the page are unambiguous, it doesn't matter what we think was meant. What matters is what the words on the page said. Should you interpret ordinances to accomplish their purpose, revealed from the stated purposes of intent, from the governing body's minutes, from staff reports, even if that interpretation varies from the text of the ordinance? And the answer to that is only if the language is ambiguous. And then you have to give the language meaning, but you should only use this approach if necessary. So again, if the zoning ordinance is clear, even if it seems to suggest an outcome that we think might not be intended, we're bound by the words on the page. Last question, should you interpret an ordinance to come up with the best result, regardless of what the text of the ordinance says? And the answer to that question, consistent with the other answers, is no. That it's not simply a matter of finding what intuitively we might think is the best result. So the first step in interpreting an unambiguous ordinance is to apply the plain and natural meaning of the words used. When applying that meaning, the key question is not what the governing body intended to enact, but what the meaning of the words of the ordinance enacted. That the governing body's intent is determined only from what the ordinance says and not from anyone thinks it should have said. This is kind of related to Mr. Reinhardt's earlier question about making statements into the record. But really the only definitive statement is what's ultimately adopted by the body as a whole. If a term is defined in the regulations, that definition applies. An undefined term must be given its ordinary or usual and customary meaning given the context in which it's used. A word that is non-technical is presumed to have been used in its ordinary sense. Dictionaries can be used as a reference, and the dictionary that we consult most frequently is Webster's Third New International Dictionary, and the reason we do is simply because that dictionary seems to be cited most often by the Virginia Supreme Court. So in determining whether an ordinance is ambiguous, it's ambiguous if it can be understood in more than one way. So if you're a poet or a lyricist, having double entendres is a good thing. If you're an ordinance drafter, it's a bad thing. Ordinance should mean only one thing. It can also be ambiguous if it's difficult to comprehend, if it's of undoubtful import, or if it lacks clarity and definiteness. The fact that the parties may disagree about the meaning of an ordinance does not necessarily mean that it's ambiguous. If an ordinance is ambiguous, the intent of the governing body must be determined by applying rules of construction. It's only if the language is ambiguous would you, again, try to determine what you think is the intent of the governing body. We're going to look a little bit at classifying uses as well, because that can be the subject of an appeal. A BZA must often determine whether a particular use is permitted in a zoning district, either as a primary or accessory uses. And there are two types of zoning ordinances when you're looking at this. There's an inclusive or permissive zoning ordinance, which permits only those primary uses specifically named. In other words, it has to be on the list, and if it's not on the list, it's not allowed. But the other approach is the exclusive, which prohibits specified uses and permits all others. In other words, it's a zoning ordinance that has a list of prohibited uses, and if it's not on that list, then it's open season. The inclusive ordinance appears to be the more modern approach to zoning. It's the more common type of ordinance in Virginia, and it's Albemarle's approach as well. That the Albemarle zoning ordinance has lengthy lists of permitted uses, but if it's not on that lengthy list, then it's presumed to not be a permitted use. There are 5 key rules for classifying uses. When the use regulations are unclear as to whether the activity is allowed, the use classification should be strictly construed by the court, or have been strictly construed by the courts in favor of the owner. We should refer and rely on the definitions in the zoning ordinance. In Albemarle zoning ordinance, all the definitions are placed in a single section of the zoning ordinance that actually runs for, I think, about 20 pages or so, but there are defined terms in the zoning ordinance, and that's where those definitions are found. Another rule of construction is that the use itself and not the owner or the nature of the owner is the relevant consideration, because again, these decisions run with the land. So it's important to put on the blinders as to who the current owner is and simply focus on the use. Whether a use is appropriate in the district is not a relevant consideration. Again, it's whether the zoning administrator was correct in the determination. And for the uses of structures, look to their function rather than their form. These are 5 good ground rules to keep in mind when constructing an ordinance. So each primary use is accompanied by a range of accessory uses, and an accessory use is commonly defined to be a use that is subordinate and customarily incidental to the primary use. And we'll talk about what each of those terms means. Subordinate means that it's minor in relation to the permitted use. And you can judge whether or not it's minor by the area devoted to the use, by the frequency of the use, whether it's an active or a passive use, number of employees or work hours, and whether it's truly subordinate, that is to say, underneath, or whether it's a different use altogether. Customarily incidental means that it's commonly, habitually, and by long practice associated with the primary use. And again, you look at these four elements on the screen: the nature of the primary use, the use made of adjacent parcels, the economic structure of the area, whether the proposed use is customary within the locality or region. So maybe some synonyms for subordinate and customarily incidental. Subordinate would be minor, and customarily incidental would be related. So it's got to be minor and related compared to the primary use. So here are some examples of accessory and not accessory uses. So accessory uses would be garages, swimming pools, decks and gazebos, small sheds, gardening areas. Those are accessory to single family residential use. Even though the zoning ordinance doesn't explicitly say we allow garages in residential areas, we allow swimming pool in residential areas. Just by long-standing practice, those types of structures have been associated with single family residences and therefore are deemed to be accessory to them. So the courts have also found, for example, that a crematorium is accessory to a cemetery, that stone crushing is accessory to a quarry, and then there's other examples provided in your materials. Courts have found not accessory to be barns constructed for housing heavy construction equipment that's not accessory to a residential use. They found that a large steel storage building is not accessory to a church in a residential zoning district, or that sleeping quarters for employees are not accessory to a restaurant. So these are examples of what's accessory and what's not accessory. So we're going to talk a little bit about non-conforming uses and structures as well. A non-conforming use is a lawful use existing on the effective date of the zoning restriction and continuing since that time. That's non-conforming to the ordinance. And the purpose of non-conforming uses and allowing them to continue, the code allows them to continue, and there's a specific statute, 15.2-2307A, that preserves the rights in existing lawful buildings and land uses. These rights are subject to the competing but well-recognized rules that public policy opposes the extension and favors the elimination of non-conforming uses. So over time, it's intended that these non-conforming uses ultimately disappear, go away. Perhaps not suddenly, but slowly but surely. Nonconformities are disfavored because they detract from the effectiveness of the comprehensive zoning plan. But at the same time, we have to balance that with, again, an unconstitutional taking and an owner's existing property rights. So that's what the non-conforming use rules are designed to do: preserve a property owner's rights to their existing property, while at the same time furthering the ultimate objectives of the zoning ordinance. A non-conforming use, in order to be continued as a non-conforming use, it must be substantial. It must be a primary use and be substantial. The idea is that non-conformities should protect uses where their termination would involve significant financial, property, or other economic results. If the rule were otherwise, every trivial, incidental, or insubstantial activity could obtain protected status. The burden is on the owner to establish a non-conforming use. And the reason for that is because, in theory, the owner has better access to the evidence pertaining to the historical uses of the property. Zoning staff isn't going to be monitoring every use of every property in the county. The owner presumably has better information to establish that, in fact, they've been using their property in a manner that allows them to claim non-conforming status. So here's what the prerequisites are to preserving non-conforming status. The then existing or more restricted use must continue. The use cannot be discontinued for 2 or more years. And the structures must be maintained in their then structural condition. So if you've got a use and you continue that use without an interruption of more than 2 years, you're allowed to continue that as a non-conforming use. Here's a further explanation of the existing or more restricted use must continue. The key determination there is whether the character of the use has changed, considering factors such as an increase in volume, in frequency, in land area, whether the size or scope has changed. Trivial, insubstantial, or reasonable customary and incidental change is permitted for commercial uses, but not for residential uses. So here are some examples of where the character has changed and would not be considered to be a legal nonconformity. Where general cargo became trash hauling, where warehouse and repair became assembly and fabrication, where vehicle repair became paving and sealing, or where an infrequently and privately used campground became a permanent commercial campground. In each of these cases, you would not have a legal nonconformity because the character of the nonconforming use would have changed. Here's a key rule that the use cannot be discontinued for 2 or more years. So if a property owner has a nonconforming use and then doesn't act on it for a period of at least 2 years, then it's not allowed to continue as a legal nonconforming use. Continuing the use is not necessarily limited to actual operation of the use, but may include preparatory actions like securing financing, paying taxes, obtaining a business license, or obtaining land use and building permits. So in other words, a store, for example, need not be open for business, but if an owner is taking preparatory actions such as those listed on the screen, that can continue, that can satisfy the requirement for continuing use without interruption. But merely obtaining a business license of it in and of itself is insufficient to continue use. The structures must be maintained in their then structural condition. If the structure is altered in a manner that's not authorized, the non-conforming status of the use or structure is lost. And the locality may require that the uses of a structure conform to the current zoning regulations whenever they're enlarged, extended, reconstructed, or structurally altered. So the locality can put restrictions on changes if they are changed in order to still allow a legal non-conforming status to continue. We're going to talk briefly about vested rights. And one of the frequent questions is, what's the difference between a nonconformity and a vested right? Nonconformity exists when there's a pre-existing use that may continue even though it no longer conforms to new zoning regulations. So that deals with active uses that are in effect at the time of a zoning ordinance amendment. A vested rights determination is whether a previously approved but not started use has ripened to the point that should it be allowed to exist even though it would not conform to the new zoning regulations. This is sort of like going through an intersection on a yellow light, essentially, that somebody has made enough progress down the road and has built enough momentum to where even though the zoning ordinance has changed, that they're allowed to continue down that path even though they've not yet started it. That's the analogy that I like to think of. But the determination comes to a point of, if you're not in the intersection at the time the light turns yellow, you're not allowed to enter. And that would be, I think, the analogy that I would use in determining where the cutoff is between having a vested right and not having a vested right. Generally, property owners have no property rights in anticipated use of their land. There's no vested rights in having the current zoning continued. But owners may acquire a vested right in planned uses of their land that may not be prohibited or reduced by later zoning regulation in certain cases. And there's 3 sources of that in the state law. In 15.2-2307A, it protects certain rights to a use of a property arising from a proposed lawful use that was given prior approval by the locality. So if a locality has made certain approvals, this section highlights basically where the cutoff between the yellow light and the red light. 15.2-2311C is a remedial statute that protects certain rights to a use in a manner that otherwise would be prohibited because of an erroneous determination. So when a zoning administrator has made what everybody agrees is a erroneous determination, if it's beyond the appeal period, and we'll get into more detail in this in the future, but this is an order basically to protect property owners against clear errors made by zoning administrators. And then these last 3 sections here on the slide protect certain rights to the use of a property arising from proposed lawful use where the owner has proffered certain things.
I would like to go back just for a second.
Yeah, I'll be quick, John. I'm thinking that the vested rights would be site plan approval, special use permit approval. That's kind of what, maybe building permit approval. And I think that each one of these has a time limitation on the approval process itself for site plan, special permits, and maybe a building permit. So are those the things that we're talking about here as in terms of vesting?
That's correct. It requires a significant affirmative governmental act, and we'll talk about that standard. I've got more slides that deal with exactly what is the significant affirmative governmental act.
Thank you.
Mr. Chair, you had something as well?
I just want to underline and put a box around Virginia Code Section 15.2-2311, parentheses C. That was the basis of our finding of the recent determination that is, until further notice, the subject of an appeal to the circuit court. There's a lot to that, and I think I would be happy to, I'm not asking for it now, but I'd be happy to hear more about that. And it would be and also for the staff to be well trained on that particular code section. I think it has a lot of weight, and just wanted to underline that, highlight it, and say something.
Okay.
We put a lot of effort and thought and effort into that, and significant action in our, recent past year.
And we'll talk about each of these. This wasn't my only slide on the various, this is more of an introductory slide. We'll talk about each of these standards. So the vested rights determination under 2307A, that's the first prong. It determines whether a previously approved use has ripened to the point that it should be allowed to continue to exist, even though it would not conform to the new zoning regulations. Again, going through the intersection on the yellow light. Rights will be vested when, again, the standard of significant affirmative governmental act that remains in effect, allowing development of a specific project. And Ms. Joseph had pointed out various examples: site plan approval, subdivision approval. Those types of determinations would likely be considered significant affirmative governmental acts. When the owner relies on that act in good faith, when the owner incurs extensive obligations or substantial expenses in diligent pursuit of the project. So it's not enough just to have a site plan or subdivision approval. The owner must have incurred significant expenses in diligent pursuit of actually pursuing that site plan or subdivision approval. And here's a list again of the significant affirmative governmental acts: proffered rezonings, rezonings to a specific use or density, special use permits, variances, preliminary subdivision plats and site plans, final subdivision plats and site plans, and other acts determined by the Virginia Supreme Court to be significant. So these would each be prerequisites.
Mr. Herrick, excuse me, we do have a raised hand. One moment. Leah Brumfield, I'm sorry. One moment. Leah Brumfield has a question.
Thanks, Andy, and I didn't mean to interrupt you. The question that I had was whether any zoning clearances or any type of approval of a business or clearance type thing would ever constitute a significant affirmative governmental act, or whether it's only the things that rise to a legislative action level.
It could. I don't want to necessarily say that it always would, but it could. But the owner would also then have had to prove the other prongs of this, that they would have made a significant expenditure and diligent pursuit of that clearance.
Hey, could I just ask a quick question based on that? This is Lisa Green. Sorry to interrupt again, but if applications or the staff has approved something based off of the information given by the applicant, and the applicant hasn't necessarily provided accurate information, how does that apply in this situation?
So what you're indicating?
Staff is basing a decision off of the information given to us by the applicant, and if the applicant has given us incorrect or not accurate information, that's what I'm asking about.
And are you talking in terms of a clearance or?
Any kind of application. If we're basing a decision off of inaccurate information, how does that apply in this situation?
I mean, I would think that staff would, or that the county might look into ways of revoking the application or the clearance that was granted if it was made, or saying that the property owner is operating outside of the clearance that was granted, because the clearance was granted based on one set of facts and the owner is operating under a different set of facts. So the argument would be that the owner is operating outside the clearance because it's not within the stated facts that were provided. I hate to do this, but in the interest of time, we're already running pretty well over. So I want to get through at least this topic and then see where we are in terms of where we'd like to go with the rest of this. We're looking here at examples of significant affirmative governmental acts. There has to be a reliance in good faith, that the owner must rely on that and take actions designed to move the project forward, that they must incur extensive obligations or substantial expenses in order to have a vested rights. And here you see a couple examples where owners had incurred, in one case, $158,000, in another case, $59,000. Both of those were found to be substantial expenses that allowed them to claim a vested right. And they must have, there must be a diligent pursuit of the project, that they've made extensive obligations or substantial expenses in diligent pursuit, so that they can try to move the project forward. Then the other code section that one could obtain vested rights under, and that Mr. Shepard alluded to, is when a zoning administrator or officer has made an error, and a property owner has relied on an erroneous determination that went uncorrected for more than 60 days. And the poster child for this is a case out of Richmond County, not the city of Richmond, but Richmond County, where the zoning administrator signed a zoning certificate of compliance approving a 2-story detached garage, even though the zoning ordinance did not allow a 2-story accessory structure because it was taller than the 1-story primary structure. The owners built the reliance on the certificate that the zoning administrator erroneously granted. Then there was a successor, a new zoning administrator came in and informed the owners that the garage violated the zoning ordinance, and the owners appealed to the BZA, which confirmed the notice of violation. The trial court reversed that, holding that the owners had vested rights under 2311C, and the Supreme Court upheld that as well. So again, I think this is a good example that once a zoning administrator puts out a determination that later proves to be erroneous, if the owner has relied on that erroneous determination for more than 60 days, and more than 60 days have elapsed, at that point, the scales weigh in favor of the owner being allowed to do something that goes against the zoning ordinance because they've relied to their detriment on an erroneous determination. So once vested rights are established, the land may be used as either it's been approved, whether it's been approved through the Significant Affirmative Governmental Act, or whether it's been approved erroneously under 2311C, even though, again, it's not otherwise allowed under the zoning regulations. So we've reached 12:02. We're now we're already a couple minutes over our allotted time. This is a good stopping point for me to address any questions. I've got the time to continue going, but my suggestion would be that we reserve the FOIA and the conflicts of interest discussion perhaps for another meeting in order to really do them justice. Again, I'm happy to continue. I have the time to continue if you'd like to continue. I'm happy to defer these last two parts to a later date, depending on what you all would prefer.
I would offer that I would like to defer it and also to basically do something akin to today, which could cover FOIA and meetings, as well as drill into some of these other topics a little deeper and have more, and include more discussion. I think it would particularly be interesting to have some within the lines discussion between BZA members and staff, just to gain a better shared understanding of these things. That would be my recommendation.
Chairman, I'm in a situation where I do need to go. Mr. Herrick, I got to tell you, having been the individual here that's been the longest on the Board of Zoning Appeals, we should have had this happen years ago, how much I've picked up. And as I recommended at the last meeting that we set it up annually, you have done an outstanding job of condensing everything and making it understandable. So I commend you. I understand why other locales have invited you to come speak, but compliment to your work. It was just fantastic.
Thank you.
With that, to my fellow board members, I do need to leave, and I hope you all understand that.
Okay. Thank you for the remarks there, and best wishes, Randy.
Andy, would it be possible for you to send the slides out to all the board members and me? And also I've joined Randy. The presentation was excellent. Thank you very much.
Thank you. I'd be happy to share the slides, including the slides that for our upcoming discussion, assuming that the consensus is to defer the Freedom of Information Act and Conflict of Interest Act to another meeting. I'm happy to, again, send out the materials and schedule these remaining parts for another day.
Thank you.
All right, thanks. Okay, so I guess I don't think we have to vote on that. That's clearly the consensus that that's what we're going to do. I also just want to reiterate, thank you very much, Andy. That was great. I think this is really valuable, and hope we can continue this sort of activity. I think it's going to really help us and be a good thing. So thanks for that. Is there any other new business anyone wishes to bring up?
Mr. Chair, I would just, if there's no other new business by other members, what's the pleasure of the board in terms of scheduling this next, would the board like to, the next regular meeting date would be November 10th at 2 o'clock. Would the board like to come back for this, or would the board just like to save this for the next time that there's an appeal or an application before you all?
Oh, yeah. Well, thank you for slowing me down and backing up to that. I would say anytime we have a meeting, and hopefully that would be the case in November, if there is either a nothing on the agenda or something very quick and easy on the agenda, that I would like to have another session like this. This would be difficult to have after a contentious and, vexing BZA meeting.
So I'll defer to Mr. Svoboda and Ms. Alley as to what our upcoming calendar looks like. But I would note that the next regularly scheduled date would be November 10th in the afternoon.
I know that we have 2 applications pending. I think one is in under review to see if it's complete, which is an appeal. The other is we're anticipating actually a variance coming in. I believe those are both likely to be December, but with 2 items on that particular agenda, November may be a better time to continue.
Okay, well, let's try for November, but if other things push it off the agenda, we'll have to find another time.
And I would note, for what it's worth, that I am unfortunately not available that morning, but I am available that afternoon. So, I mean, there was some discussion at the outset as to whether we should be meeting in the mornings or the afternoons. If we were to continue this on November 2nd, I would need to do it in the afternoon of, November 10th. I would need to do it in the afternoon of November 10th.
We could certainly do that. That is the standing meeting time.
Mm-hmm. And it's on the approved calendar. So,
Exactly.
It sounds like that's when you would like to continue this, is to November 10th at 2 p.m. to continue this.
Yes. Everyone's in a grim, I don't see where we need to vote on this. I'm just seeing a lot of thumbs up. That's the consensus. That's moving forward with that.
Basically, you're setting the agenda for the next scheduled meeting, so a vote wouldn't be required.
Right. Okay. Look forward to that. So now I want to move, I think we're set with that. Move along to asking if anyone else has new business they wish to bring up. Okay, I would entertain a motion to adjourn.
I move we adjourn.
Is there a second?
I second.
Okay, so Ms. Joseph has made a motion to adjourn. Mr. Carrington has seconded that. Marcia, will you please call the roll?
Ms. Joseph,
Yes,
Mr. Robb,
he's gone.
he's already left. Okay. Mr. Carrington,
Aye.
Mr. Reinhardt, did he have to leave immediately as well? I'm not
Yes.
seeing him either. and Mr. Shepherd.
Yes.
All right.
Okay.
Thanks
Nice
again.
meeting
Thanks again, Andy. You did great.
Thank you. My pleasure. And we will see you on November 10th at 2 p.m. then.
Thank
Very
you.
good. This is, I really appreciate this. So enjoy the rest of the month.
Thank you. See you next month.
Other side of the election.